and several other books. Over to you, sir.
A warm good afternoon to all, and thank you for giving an opportunity for presenting on the current topic, intellectual property rights. We all know the relevance of this current topic in the right scenario, and once again, I thanking you for the institution and also giving an opportunity for me for presenting the topic. So we all know what is intellectual property rights, and you know your rights. So we have an overview on intellectual property rights, and this is the topic which I am going to discuss here, and the law governing the IP and what is the meaning with regard to intellectual property, and we have different types of intellectual property rights, basically patent, trademarks, copyright, and what is the remedy for infringement or there is any violation on the intellectual property rights, and with regard to some case studies and a conclusion section. So we all know World Intellectual Property Rights Organization as well, which is to be mainly established by the UN by a convention in 1967. So it's a specialized agency of the United Nations, and which means to protect the IP regime throughout the world. And its headquarters in Geneva and Switzerland. So the April 26th, we all celebrated as the World Intellectual Property Day, and the main thing is to be the visionary innovators. So the last year on the World Intellectual Property Day, the World Intellectual Property Organization's focus is on the promoting the visionary innovation as a key to a secure future. Basically, all things start from a basic an idea, and we have an idea which is to be executed in a proper manner, and you become a good innovator, and you have become a good entrepreneur like that. So there are many big and small intellectual property law firms worldwide in India, like US, UK, etc. The providing qualitative help to inventors and creators of products. So when you consider in India, the IP rights are safely protected and controlled by well-established statutory and judicial framework. So apart from that, there are many attorneys and law firms of intellectual property in India in various states, providing the service sector and how it is to be registered a new IP, or what is the remedy for infringement of the intellectual property laws. So we move on to what is intellectual property. So basically, IP is a property that arises from a human intellect. So it is a product of a human creation, or human idea, or human just to be created from the mind of human being. And what is the relevance of creativity? That is the main thing. The IP is to be more beneficial or more important in the current world. So intellectual property is comprises of two distinct forms: the literary and artistic works and industrial property. So industrial properties include patents, trademarks, copyrights. All things are within the definitions of the industrial properties. And we all know we have literary and artistic works. There are books, paintings, musical compositions, plays, videos, radio or TV programs, performance and other artistic works, and how they are to be protected, which is to be protected by the Copyright Act. So next, industrial properties. So industrial properties describe the physical matter that is a product of an idea or a concept for commercial purpose. So how they are to be protected. If you get a patent, it is to be protected under the Patent Act by patented objects, or if it is a trademark, it is to be protected by the Trademarks Act. And if it is a design, if you provide a design for a new object, it is to be protected under the Designs Act. And if you give a trade secret, and it's also be protected under the patent regime. And we have layout designs and circuits that also semiconductor chips, which is to be deal with the electronic equipments or new things, which is to be handled by the layout and semiconductor acts. And with regard to the geographical indications, which also be protected under the Indian scenario, we have Geographical Indications Act. These are all the basic laws which regulate the IP regimes in India. So major types of IP which includes patent, copyright and trademark. This is the most three more popular IPs in India. Apart from that, we have industrial designs, trade secrets, layout designs and geographical indications. So when you consider with the patents, the three things are basic need for registering a patent. It is to be novel, or it is to be commercialized, or it should be very new, and there should be a process for the invention. So when you consider the Patent Act 1970, and it is to be again amended in 1999 and 2000, these all are things we not much relevant, but you have to know what is the changes or what are the recent changes in the current Patent Act. So we have a functional and technical inventions, and which is based on purely artistic works. It is to be protected under the Copyright Act. And that particular act is also to be amended and altered in recent times. And with regard to Trademarks Act 1999, like it's any symbol, logo, word, sound, color, design, etc., which is also be protected under the Trademarks Act 1999. These are a pictorial representations with regard to what is to be copyrighted. If you don't see a problem with this question, you need the class. From this, I start the class. What is the real problem with regard to this picture? All I asked was, can I patent my copyrighted trademarks? Whether it is possible or not. That is the question. The person comes to an office and asks him, whether can I patent my copyrighted trademarks? If you don't see any problem with this question, you have to know more on the IPs. Otherwise, you know the exact meaning, what the question belongs to that. So we move on to patent. Patent is covered under the act called Patent Act, and it extends to the whole of India, and it shall come into force by introducing the central government by a particular notification in the official gazette. So, next one, the definition of patent. The patent describes an invention for which the inventor claims the exclusive right. First of all, once you get the patent, you have the exclusive right over that particular product or a process. The patent maybe is like process or a product. So, invention is patentable if it must be new, useful, not obvious, and pertains to a patentable subject matter. These three things, or these four essential things is needed for invention. Then only you get the patent. And what are the patentable subject matters? Invention means it relates to a process or product or both, and which includes an inventive step and be capable of industrial application and a commercial aspect. And the life and duration of patent, the term of patent is 20 years from the date of filing for all the types of inventions. And the priority days is first to file. That is the exact thing. Once you file before the patent office, around 1.5 years is to be taken for process. Then only after completing the process, you get the patent. So the date of patent is the date of filing the application for patent. So the term of patent is counted from this particular date. So actually the 20 years is the real tenure for giving a patent. Once you get the patent, it is to be utilized for 20 years. After 20 years, you can renew the patent, or otherwise you can, if you more updations on that particular object, you can again file an application before the patent office. If you not renew the patent, your patent is to be cancelled after the 20 years. So the basic fees, the government fee for filing a patent application in India is only just 750 for individuals and 3,000 for legal entities. Legal entities like companies or partnerships. These are all the legal entities. So the no fee for first and second year, the renewal fee on yearly basis is required to be paid for 3rd to 20th for keeping the patent in force. So you have a renewal fees and you have a yearly basis fees also for that. And the patent lapses if renewal fee is not paid within the prescribed period. This is the most important thing. Once you get the patent, you won't allow to, or you don't, and you never pay the fees. It is to be cancelled. Then is a patent granted in one country is enforceable in another country? That is the one important doubts which around you. So actually it is no. There is nothing like a global patent or a world patent. So the patent rights are essentially in territorial in nature. If you get your patent in India, you can utilize or you have an exclusive right that particular product within the territorial limits of India. You cannot utilize in the other nations or other states. So granting a patent in one country of the union does not force other countries to grant the patent for the same invention. If you get a patent in India and you also apply for patent in America, the American government is not enforceable to give that patent for that particular product in America because it is already, if they are patent in America, you never get the patent. So the refusal of patent in one country does not mean that it will be dominated in all countries. So actually, you get a patent in only one country, or otherwise you can get a patent in another country by filing a separate application in that particular country. Then only you get the patent in the America or US or UK, anywhere in the world. Then the patent holders in India. A list of top 10 patent holders in India comprises of only pharmaceutical and biotech companies. So in India, 184 patents are held by Council of Scientific and Industrial Research, followed by Rantaxi, the famous pharmaceutical companies are the most important patent holders in India. While the top 10 patent holders across the world are IT companies in India, and no IT firm has patents. So this is one of the case study which I boost your like students like you. You can do that. It's one of the youngest patent holder on a wheelchair. He is a handicapped boy, and he is from Jaipur, and drawing inspiration from a scientist, Stephen Hawking, the famous wheelchair-bound 9-year-old boy here has invented a game of 6-player circular chess. The boy Hrideshwar Singh Bhati has got a games design patent in his name. So he introduced a new type of a chess player. It used to be around 6. We all know the chess used to be handled only by up to maximum 4. Or otherwise it used to be by 2 persons. So this is the game or a chess designs patent or chess designs games patented by that particular boy. It's one of the important case study in India. And this is a copy of certificate of grant of patent, and the certificates includes all things: the patent number, the proprietor, inventor, and it is to be, and also the date of patent is also to be engraved in the certificates. So this is a certificate issued from the United Kingdom Patent Office, and India we have a patent office in Chennai. Is a central office which is to be established by a particular act. And once you get the patent, you can file an application before the Chennai office, and after your application will be scrutinized, the patent will be granted by the office. Then next one, trademark. So it is covered under the act called Trademarks Act 1919, and the act came into effect on September 15th, 2013. And it replaced the Trade and Merchandise Marks Act 1958, and it extends to the whole of India. This will also be a central act passed by the central government of India in 2003 from effect, but this act is to be 1999 act. So what is trademark? So a trademark is a symbol, logo, word, sound, color, design, or other device that is used to identify a business or a product in the commerce. So we have different symbols for indicating a trademark. And the TM is intended to use application file for product, and SM intended to use application file for service, and R represent the registered trademarks. You see these marks in the particular product packets, TM, SM, and R, which belongs to different symbols which has to be used for the registered trademarks which are used in their particular products. So what is the registration procedure for trademarks? First of all, application for search, then application for registration, then examination of trademarks, then advertisement of trademarks, then filing of opposition, and finally the certificates will be issued. And the duration and fees of trademarks. The trademark is valid for 10 years from the date of application, which may be renewed for further period of 10 years on payment of prescribed fees. The trademarks means the right to reserved exclusively for owners for 17 years, and it can also be renewed. So trademarks are basically different trademarks. Trademarks ഉണ്ട് അതേപോലെ തന്നെ service trademarks ഉണ്ട്, which is to be exclusively for 17 years. So the government fee is rupees 2,500 for each class of goods or services, which has also been paid by the trademark holder. Then what is the applicability of trademarks? The trademark is a sign used on or in connection with the marketing of goods or services. And the term use on the goods means that it may appear not only on the goods themselves but on the container or a wrapper in which the goods are when they are sold. That is the main purpose or why how the trademark is to be affixed in a particular product. Basically, it is to be affixed in the container or a wrapper in which the goods are when they are sold. Then you all know that apart from the surrounding text, the Raymond Textile is India's leading producer of worsted suiting fabric with over 60% of market share. So the Raymond Textile is India's leading producer of worsted suiting fabric with 60% of market share. So I show the two letters, Raymond Textile. The first thing is the current wordings and the current style and the correct font to represent the Raymond Textile. The second thing is the incorrect text. So these are the famous Vimal Eftosa, the leader is working holds in ceramic accessories. These are different trademarks that they are used for branding their product. Specify the font, size, proportion, and placements. So incorrect thing is also I show here. Then do not change the spellings. Spelling is also important with regard to the trademarks. Once you get the trademark with the correct spelling and you don't use the different spelling in the other label, is against the trademark registration procedure. So Calvin Klein എന്ന് പറയുന്നത് നമുക്ക് ഞാൻ കാണിച്ചിട്ടുണ്ട്. കാൽവിൻ കെലിൻ എന്നുള്ളത് സ്പെല്ലിംഗ് തെറ്റാണ്. സോ അതെന്ന് പറയുന്നത് റോങ്ഫുൾ ആയിട്ടുള്ള ട്രേഡ്മാർക്ക് ആണ്. Then you also know the trademarks, different trademarks. Coca-Cola, Adidas, McDonald's, Orange. ഇപ്പോൾ ഇവിടെ കൊക്കക്കോള കാണിച്ചിരിക്കുന്ന ഒരു ട്രേഡ്മാർക്ക് എടുത്തിരിക്കുന്നത് അവരുടെ നെയിം വെച്ചിട്ടാണ്. ഹൗ ദേ ഹാവ് ടു റൈറ്റ് ദെയർ നെയിം കൊക്കക്കോള എന്നുള്ളത് ഇറ്റാലിക്സ് വേർഡിലാണ് അവിടെ എഴുതിയിരിക്കുന്നത്. ഇനി ലോഗോ ടൈപ്പ് എടുക്കാം. അതേപോലെ തന്നെ മാക്ഡോണൽഡ്സ് അല്ലെങ്കിൽ ആ സിമ്പിളാണ് അവരെടുത്തിരിക്കുന്നത്. ഇനി സ്ലോഗൻ എടുക്കാം, ഐ ആം ലവിങ് ഇറ്റ്, അതും ഒരു ട്രേഡ്മാർക്കാണ്. ആൻഡ് വിത്ത് റിഗാർഡ് ടു ദി ഓറഞ്ച്, അവർ പർട്ടിക്കുലർ കളറിലാണ് അവർ ട്രേഡ്മാർക്സ് ചെയ്തിരിക്കുന്നത്. സോ ദ ഡിഫറെൻറ്റ് ആസ്പെക്ട്സ് ഉണ്ട്. സോ വി മൂവ് ഓൺ ടു ദി കോപ്പിറൈറ്റ്. ദി കോപ്പിറൈറ്റ് ഗവേൺസ് ദി സിസ്റ്റം ഓഫ് കോപ്പിറൈറ്റ്സ് ഇൻ ഇന്ത്യ, ആൻഡ് അഗെയിൻ ഇറ്റ് ഈസ് ടു ബി അമെൻഡഡ് ഇൻ ദി റീസെന്റ് ഇയേഴ്സ്. So it is a right which grants protection to the unique expression of ideas. So the term original in the copyright law means that the work originated with the owner and there is no requirement for novelty or uniqueness as there in patent law. So copyright എടുക്കുകയാണെങ്കിൽ നമുക്കിവിടെ നോവലിറ്റിന്റെ യുണീക്നെസിന്റെയും ആ ഒരു മാൻഡേറ്ററി റിക്വയർമെന്റ് ഇവിടെ ആവശ്യമില്ല. So the copyright protects the expression of an idea and not the idea itself. we have a freedom of speech and expression, and you have to express your own ideas, and you have to write your own poems, pictures, everything, which is to be covered and it is to be protected under the copyright. So what is covered by copyright? You know what the literary works, like books, poems, stories, even cinema scripts, is also be literary works. Then films, then dramatic arts, then musical compositions, then artistic works, drawings, paintings, then sound recordings, film songs. All see always has to be protected under the copyright. Then what is not covered by copyright? ഇനി കോപ്പിറൈറ്റ് കവർ ചെയ്യാത്ത കാര്യങ്ങളുണ്ട്. റെസിപ്പീസ് ഒരിക്കലും കോപ്പിറൈറ്റഡ് അല്ല, ഫാക്ട്സ് കോപ്പിറൈറ്റഡ് അല്ല, ഐഡിയാസ് കോപ്പിറൈറ്റഡ് അല്ല. ദ വർക്ക്സ് ലാക്കിംഗ് ഒറിജിനാലിറ്റി ലൈക്ക് ദ ഫോൺ ബുക്ക്, then names, title or short phrases are not protected under the Copyrights Act. ഒരാളുടെ നെയിം ഒരാൾക്ക് ഇട്ടിരിക്കുന്ന പേര് വേറൊരാൾക്ക് ഇടുന്നതിൽ അവിടെ ഒരു കോപ്പിറൈറ്റിന്റെ വിഷയം വരുന്നില്ല. അതേപോലെ തന്നെ ടൈറ്റിൽസ്, ഡോക്ടർ എന്നോ അല്ലെങ്കിൽ ലെഫ്റ്റനന്റ് എന്നോ ഇതൊന്നും ഒരു കോപ്പിറൈറ്റഡ് ആയിട്ട് ഒരാൾക്ക് പർട്ടിക്കുലർ ഇൻഡിവിജ്വലിന് മാത്രമുള്ളതല്ല. Then registration procedure is also same. The register a copyright by completing a simple application form along with the copyrighted fees. Then need not send a copy of your work, and it may appear with the same title, but if each work has been created independently, each will have its own copyright protection. പിന്നെ ഇവിടെ ഡ്യൂറേഷൻ ഓഫ് കോപ്പിറൈറ്റ് എന്ന് പറയുന്നത് ഓതേഴ്സ് ലൈഫ് ടൈം പ്ലസ് 16 years ആണ്, നോട്ട് 15 ഫ്രം ദ എൻഡ് ഓഫ് ദി കലണ്ടർ ഇയർ ഇൻ വിച്ച് ദ ഓതർ ഡൈസ്. അപ്പോൾ ഓതർ മരിച്ചതിന് ശേഷം പ്ലസ് 16 years ആണ് കോപ്പിറൈറ്റിന്റെ ഏകദേശം അതിന്റെ കോപ്പിറൈറ്റ് ലാസ്റ്റ് ചെയ്യുന്നത്. ദെൻ 50 years ഫോർ ഫിലിംസ് ആൻഡ് സൗണ്ട് റെക്കോർഡിംഗ്സ്, 25 years ഫോർ typographical arrangements of a published edition. The copyright protection always expires on December 31st of the calendar year of the protection. ഒരു substantial period ഇവിടെ കാണിച്ചിട്ടുണ്ട്, December 31st. Then what is fair use? Gives permission to use copyrighted material if certain criteria has met, protect the freedom of speech, promote public benefits like education. അങ്ങനെയുള്ളതൊക്കെ ആണെങ്കിൽ നമുക്ക് ഫെയർ യൂസ് എന്ന് പറയുന്ന ഡെഫിനേഷൻ്റെ ഉള്ളിൽ കൊണ്ടുവന്നിട്ട് യു ക്യാൻ യൂസ് ദ കോപ്പിറൈറ്റഡ് മെറ്റീരിയൽസ്. ഇപ്പോൾ എഡ്യൂക്കേഷൻ പർപ്പസിന് വേണ്ടിയിട്ട് പലരും എഴുതിയിരിക്കുന്ന ബുക്സ് നമുക്ക് റീറൈറ്റ് ചെയ്യാം, അസൈൻമെന്റ് എഴുതാം. അതൊക്കെ ഫെയർ യൂസ് എന്നുള്ള രീതിയിലാണ് നമ്മൾ കാണുന്നത്. ആൻഡ് ബിവെയർ ദ ഫെയർ യൂസ് എക്സ്ക്യൂസസ്. ഒരിക്കലും ഫെയർ യൂസിന്റെ ആ ഒരു എക്സെപ്ഷൻ എടുത്തിട്ട് നമ്മൾ ഒരിക്കലും കോപ്പിറൈറ്റഡ് മെറ്റീരിയൽ നമ്മൾ യൂസ് ചെയ്യാൻ പാടില്ല. They never assume that your use falls under the fair use exception. Saving money is not a sufficient cost, and the laziness can be a trap. So beware of the fair use excuse. And how much can I use? The photos and images up to 5 works from one author, up to 10% or 15 works, whichever is less from the. These are not much relevant. And if there is a breach of IP, or if there is an infringement, what are the remedies available under the different enactments? So any reproduction, use, distribution, performance, etc. of a work without the permission of the owner, an identical or substantial similar reproduction is also covered. The basic infringement എന്ന് പറയുന്നത് damages ആണ്, അതേപോലെ തന്നെ injunction ആണ്. You can file a stay order or you have to file an injunction suit before the court. And what is the remedy for patent infringement? A suit can lie in the district or high court. നമുക്ക് കോടതിയിൽ സമീപിക്കാം. And it may issue an injunction either to prevent the infringer from any further use and award damages to the patent owner, or will pay the patent owner the royalties for further use. That is one of the remedies in the patent infringement. Then this is one of the case study. The Apple sued filmmaker HTC and filed a complaint with the US International Trade Commission alleging that the Taiwanese company is infringing the 20 Apple patents related to the iPhone. അപ്പോൾ ഇതൊരു ഐഫോണുമായിട്ട് ബന്ധപ്പെട്ടിട്ടുള്ള ഒരു പേറ്റന്റ് റിലേറ്റഡ് ഇഷ്യൂസ് ആയിരുന്നു. അപ്പോൾ അവർ HTC കമ്പനീനെ സ്യൂ ചെയ്തു. So the Steve Jobs, the Apple CEO, said in the statement, "We think competition is healthy, but competitors should create their own original technology but not steal others." This is the wording from the Steve Jobs. ആപ്പിളിന്റെ CEO പറഞ്ഞിട്ടുള്ളതാണ് ആ കേസിൽ. അവർ കോമ്പറ്റീഷൻ healthy competition അവർ അനുകൂലിക്കുന്നു. പക്ഷേ കോമ്പറ്റീറ്റേഴ്സ് ഷുഡ് നോട്ട് ക്രിയേറ്റ് their own ഒറിജിനൽ ടെക്നോളജി ബട്ട് നോട്ട് സ്റ്റീൽ അതേഴ്സ്. അത് മറ്റുള്ളവരുടെ മോഷ്ടിക്കുകയല്ല വേണ്ടതെന്നാണ് പറഞ്ഞിട്ടുള്ളത്. Then remedies for trademark infringement. A suit can lie in the district or high court. നമുക്ക് ഈ രണ്ട് കോടതിയെ സമീപിക്കാം. Then punishment is extended from 6 months to 3 years ആണ്. The permanent bans on engaging in the commercial activities. അതും ഇവിടെ ഒരു infringement ആണ്. The example for successful civil application. So a suit filed by Adidas, Salam and AG in the Delhi High Court against the counterfeiters. So at the initial stage, an infringing goods were seized by the local commissioner, and the cases were decreed. Resale and damages of 50 lakhs were awarded to the Adidas. നമ്മൾ ഓൺലൈനിലൊക്കെ പല രീതിയിലുള്ള ചീറ്റിംഗ് നമ്മൾ കാണുന്നതാണ്. അപ്പോൾ അഡിഡാസിന്റെ പ്രോഡക്റ്റുകൾ ഇതേപോലെ തന്നെ പലരും മിസ്യൂസ് ചെയ്യുന്നുണ്ട്. പല ലോക്കൽ ബ്രാൻഡ്സിന്റെ കമ്പനികൾ അഡിഡാസിന്റെ പ്രോഡക്റ്റ് ആണെന്ന് പറഞ്ഞ് കസ്റ്റമേഴ്സിന് കബളിപ്പിക്കുന്നുണ്ട്. അപ്പോൾ അതിൽ അഡിഡാസ് ചലഞ്ച് ചെയ്തൊരു കേസാണ്. അതിൽ 50 lakhs ആണ് അഡിഡാസിന് അവാർഡ് ചെയ്തിട്ടുള്ളത്. കോപ്പിറൈറ്റ് ആണെങ്കിലും അതിന്റെ പണിഷ്മെന്റ് എന്ന് പറയുന്നത് 3 years ഇംപ്രിസൺമെന്റ് ആണ്. അതേപോലെ തന്നെ ഫൈനും ഉണ്ട്. Then copyright claims on the basis of underlying artistic works. അപ്പോൾ ഇത് ഒരു പർട്ടിക്കുലർ പ്രോഡക്റ്റ് ആണ്. ആ പ്രോഡക്റ്റിന്റെ ഡിസൈൻ ആണ്. ആ ഡിസൈൻ പല രീതിയിലാണ് കൊണ്ടുവരുന്നത്. സോ ഇറ്റ് ഈസ് ടു ബി ഒരു ആർട്ടിസ്റ്റിക് വർക്ക്സ് ആണ്. നമുക്ക് കാഞ്ചീപുരം സിൽക്സ് അല്ലെങ്കിൽ കാഞ്ചീപുരം സാരീസ് ഒക്കെ ഇട്ടുണ്ട്. അതൊക്കെ ജോഗ്രഫിക്കൽ ഇൻഡിക്കേറ്റർ ആണ്. അതേപോലെ തന്നെ അതിന്റെ ഡിസൈൻസ്, അതേപോലെ തന്നെ അതിൽ കോപ്പിറൈറ്റ് പല രീതിയിലാണ് അവർ IP റെജീമിൽ പ്രൊട്ടക്ട് ചെയ്തു വെച്ചിരിക്കുന്നത്. അപ്പോൾ that depends on different aspects. So these are all ഇന്നസെന്റ് ഇൻഫ്രിഞ്ച്മെന്റ് ആയിട്ടാണ് നമ്മൾ ഇതിനെ കാണുന്നത്. പല ഒരു ചെറിയ വേരിയേഷൻസ് ഒക്കെ വന്നാൽ അതിനെ നമ്മൾ കോപ്പിറൈറ്റഡ് ആണ് അല്ലെങ്കിൽ എന്ന് പറയാൻ നമുക്ക് വിളിക്കില്ല. ഒരു ഇന്നസെന്റ് ഇൻഫ്രിഞ്ച്മെന്റ് എന്നുള്ള രീതിയിലാണ് നമ്മൾ അതിനെ കാണാനായിട്ട് സാധിക്കും. Then occurs when infringer was unaware that the things were protected. So no excuse if properly displayed, like patent, trademark symbols, copyright notice. So like also sarees at 2011 to 2012. അങ്ങനെ ആയിരിക്കും അവർ അത് എഴുതിയിട്ടുണ്ടാവുക. So these are the basic things which I going to disclose here. And the next is if you have any doubts, you can ask. First of all, concluding my remarks, to create yourself rather than using others' creations. So ഇതാണ് പറയാനുള്ള കാര്യം. എന്തെങ്കിലും ഐഡിയ ഉണ്ടെങ്കിൽ you can create yourself. അതല്ലാതെ you cannot steal from others. Then do not use competitors' marks in such a way that it harms competitor in an unfair way. So the no comparisons that are likely to cause more confusion. So the technological advancement made the job of the creator is easy. So it also made the job of the copier easy. So you should be very beware on before registering the patents. നമ്മൾ എന്ത് കാര്യങ്ങൾ ഡിസ്ക്ലോസ് ചെയ്യുമ്പോഴും അതേപോലെ തന്നെ മേക്ക് ചെയ്യുമ്പോഴും ഇൻഫ്രിഞ്ച്മെന്റ് വന്നാൽ തന്നെ നമ്മൾ കോടതിയെ സമീപിക്കുമ്പോഴും യു ഷുഡ് ബി വെരി വിജിലന്റ് ആൻഡ് കെയർഫുൾ. ദിസ് ഈസ് മൈ പ്രസന്റേഷൻ. താങ്ക് യു ഓൾ.
Thank you, sir, for giving your valuable insights on intellectual property rights. So with that, we will go ahead and take some time for Q&A. You can unmute and ask the questions, or you can ask your questions in chat box.
The first question I got, what is the difference between R and TM in the copyright? Not in copyright, it is to be in trademark. R represent the registered trademarks and TM is for representing the trademarks, so it only belongs to trademark.
Participants, you can unmute and ask the questions.
And one question from Ashwati Sadish. And which type of products are given patent? Basically, the product is given for anything that is to be patented. But the only thing is that it is to be for a commercial purpose. It can be utilized for commercial purpose. Then only you get the patent for that particular product. Even anything comes under the product. But like equations or anything, graphic representations, like not like that thing just to be not patented. പിന്നെ അതേപോലെ തന്നെ മെഡിക്കൽ തിങ്സ് അതൊന്നും നമുക്ക് പേറ്റന്റ് ചെയ്യാൻ സാധിക്കില്ല. അതല്ലാതെയുള്ള ഒബ്ജക്റ്റുകൾ അല്ലെങ്കിൽ ഒരു മനുഷ്യൻ അല്ലെങ്കിൽ ഒരു ഇൻഡിവിജ്വൽ പേഴ്സൺ അല്ലെങ്കിൽ ഒരു സൊസൈറ്റിക്ക് സമൂഹത്തിന് ഉപയോഗമുള്ള എന്ത് കാര്യങ്ങളും നമ്മൾ ഇൻവെന്റ് ചെയ്ത് കഴിഞ്ഞ് കഴിഞ്ഞാൽ അതിന് പേറ്റന്റ് കിട്ടും.
Any other queries? The feedback form will be available on the chat box. So we have come to the end of our webinar. And now I would like to invite Ms. Ashwati Satish for vote of thanks. Thank you all once again for participating in the webinar. The session ends here. The feedback form must be full.